May it please my lady, the Chief Justice and judges of the Supreme Court. It's my pleasure to appear before you this morning. I will be dealing with three issues that were identified by the court. The first issue is regarding the question whether the president can be sued for actions taken by him or not taken by him in accordance with the Constitution. I will then be dealing with the question of whether the second schedule to the Constitution of Kenya Amendment Bill 2020 was unconstitutional. And finally, I'll be dealing with the question of whether the president can initiate the process of popular initiative. My lords and my ladies, we have filed our submissions. The AG submissions on the issue of the presidential immunity, which is the first issue that I will deal with, is found at paragraphs 93 to 120, which is pages 23 to 29 of the submissions dated the 24th of November 2021, and paragraphs 59 to 85, which you'll find at pages 19 to 26 of our supplementary submissions dated the 14th of January 2020. Now, the issue that is posed before you, my lords and my ladies, is the question of whether the president can be sued in his personal capacity for acts taken by him in the course of discharging the functions of his office. And I think to lay the background to this, to our answer to this question, is important to understand why is it that the Constitution at Article 143 granted the president immunity. And the first thing that you'll notice in Article 143 of the Constitution is that it is headed protection from legal proceedings. So that the whole essence of Article 143 is to protect the holder of the office of the president from legal proceedings during his tenure of office. Now, what is not in dispute is that the provisions of Article 143(1) immunize the president from any criminal proceedings, whether during the time, which occurred during the time that he was in office, or even the continuation of proceedings in relation of matters that occurred prior to his assumption of the office of the president. Now, what, however, is in contention is the provisions of Article 143(2), which relate to civil proceedings. Now, my lords and my ladies will notice that Article 143 is worded that civil proceedings shall not be instituted in any court against the president or the person performing the functions of the office during their tenure of office in respect of anything done or not done in the exercise of their powers under this Constitution. Now, my lords and my ladies will find the functions of the president are set out in Article 132 of the Constitution. So starting from Article 131, it gives what is the authority of the president and gives various roles that the president plays, including that he's the head of state and government. He is also the commander-in-chief of the Kenya Defense Forces and so on. But critically, because I'll come back to this issue, at Article 131, 1D, he is also the chairperson of the National Security Council, which is in charge of ensuring the security of this country. Then the functions, as I said, are set out in Article 132 of the Constitution. Now, it is also important, my lords and my ladies, to note the provisions of Article 135 of the Constitution, which says every decision of the president in the performance of any function of the president under this Constitution shall be in writing and shall bear the seal and signature of the president. So that the actions we are saying are undertaken by the president in the discharge of the functions of his office under Article 135 are in writing and bear his signature and seal. And anything that does not is not in writing and bearing his seal is not a decision that has been made by the president in the discharge of the function of his office. So that, for instance, the president cannot declare that he has appointed a minister without that being put in writing and bearing his signature and seal. Why this is critical is because it informs the discussion that we'll be having regarding the immunity granted to the president. Now, my lord, this country has adopted a system of governance that requires three arms of government to operate independently but effectively. All three arms of government must perform their duties, but must operate effectively. And that includes the executive, which is headed by the president, and the legislature, which is headed by the speakers of the two houses, and then the judiciary. So in determining this question, why was it necessary for the president to be granted immunity under Article 143(2) of the Constitution? And my lords and my ladies, the answer is simple. First, it is necessary that the president has decisional freedom to make decisions that are key and important to safeguard the interests of the country. He occupies a unique position in which on a daily basis he has to make decisions that affect the lives of Kenyans. And my lords, if the president is detracted because of the fear that every decision he makes may attract civil liability against him, it would have a chilling effect on the ability of the president to make decisions that are important for the purposes of the people of Kenya. And a case in point, because I don't want to make this abstract, a case in point is, for example, the lockdown following the emergence of the coronavirus in Kenya. Now, my lord, at that time, it is common knowledge that worldwide, the information regarding how this disease spreads was very limited, but the president has to make a decision immediately. The consequence of that decision and the consequence of the lockdown is that there were financial and economic effects on many people. Now, can the president be sued if it turns out much later that, in fact, it was not necessary to lock down the country? If that was the case, no president would, when faced with a situation such as that, order the lockdown of the country, even if it's for the benefit of the people, because of the fear that he may be sued and found personally liable for the actions that he has taken. And it is precisely because such events occur all the time that the president is immunized from liability. The second one, my lords and my ladies, and it's a critical one, is that in many instances, the president may also have to make decisions that affect the national security of this country, including taking steps against enemies of this country, both foreign and domestic. And from our recent experience, we know that there are many instances where we have enemies of this country that are domestic. Now, my lords and my ladies, if it was possible for the president to be sued for the steps that he takes in those circumstances, you can imagine a situation where the president has to defend himself, and there is an application that is made for discovery as to why he made the decision that he made. Or, for the purposes of defending himself, he has to disclose the basis on which he made the decision that he did, whether right or wrong. My lord, there are many people, enemies of this country, that would be very happy to receive information as to how the president makes his decision and who gives him that information. That would be inimical to the interest of this country. And it is for that reason that the immunity provisions in Article 143(2) are given. And my lords, as I wind up on that issue, it's also important to remember that invariably the president, because the appointment of the president in this country is through a competitive process, every time the president takes office, there are people who don't agree with some of the decisions that he makes for political reasons. If it was possible for the president to be sued for every action that he takes, there would be many people who don't agree with his decision for political reasons that would be filing cases against him, that he must then dedicate time and resources to defend himself, so that in the process, my lord, he is then detracted from his core business of carrying out the function of his office for the benefit of the country. And so, my lord, to avoid subjecting the head of state to these kind of suits, that is the whole purpose of Article 142(3), which protects the president from proceedings during the time that he is president. And my lord, the last issue that I just want to comment on that point is that the president is also granted this immunity to avoid a situation where the head of one arm of government, that is the president, is then appearing before another arm of government. And my lord, can imagine the specter of the president being required to attend proceedings before courts of law. And the question that, my lord, arises, and we have raised it in our submissions, is what would happen if a finding of liability is made during the time during the tenure of the presidency? Can the court then issue, for example, warrants against the president? can attachment be undertaken against the property of the president? It is to avoid those situations that Article 142.3 was put in place. And so, my Lord, the Court of Appeal completely erred in its interpretation of Article 143.2 of the Constitution. I will not repeat what the learned Solicitor General said, but I agree entirely with him that what the Court of Appeal and the High Court was suggesting is that it is possible to demarcate between those suits that genuinely raise a situation where the president has acted outside of his powers under the Constitution and those that have not. Invariably, given our system of dispute resolution, it would require first that the suit is filed, the president engages a lawyer and defends those proceedings with the possibility that at the end of those proceedings it might be found, actually he acted within the confines of his power, but by which time the immunity has already been rendered superfluous. And that is why, my Lord, the artificial distinction between what the court referred to, that there's a certain action that have been taken outside the confines of his power and the others, my Lord, becomes difficult to rationalize. And my Lord, the fact that under Article 142 of the Constitution, there is no distinction there is no period, there is no similar provision as Article 143.3, which then says the president can be sued in respect of certain matters after he leaves office, and I'm coming to that. In Article 143.2, there is no similar provision saying that after he leaves office, then he may be sued in respect of certain actions that he took. And that is deliberate. And going to Article 143.3, my Lord, it's a humble submission that the Court of Appeal either did not interpret the provisions of Article 143.3, or where they did, they got it wrong. And my Lord, I say this for this reason. If you look at the provisions of Article 143.3, they provide, my Lord, that the president may be sued in respect, or sorry, they suspend the period of time within which proceedings can be brought against the president. And just for clarity and for record, it says where provision is made in law limiting the time within which proceedings under Clause 1 or 2 may be brought. Now, this is the civil proceedings. Now, my Lord will realize that the only statutes that deal with suspension of time for purposes of bringing proceedings are limited to private law. So we are looking at the issue of tort, we are looking at contract, we are looking sometimes into issues in land law. Those are the only circumstances under which time is suspended. In public law, there is no suspension of time. Under the Constitution of Kenya, you cannot plead limitation of time in respect of anything brought under the petition. And so, my Lord, you can see that the Constitution deliberately carved out private actions by the president that have nothing to do with the discharge of the function of his office, and those are the actions those are the suits that can be brought after he leaves office. And my Lord, this answers the hypothetical question that was posed by His Lordship Justice Kiage about what happens if the president's dog bites somebody. That has nothing to do with the discharge of his official functions. Correct. Or what happens if, in the course of demarcating his land, he encroaches on somebody else's land. All those, my Lord, the position is that that suit can be brought, but after he leaves office. He cannot be sued during the time that is in office. That is the whole essence of Article 143.3. The question then may be posed, are you saying that in respect of anything that he does under the Constitution that is violative of the Constitution, he is completely immunized? That's not a submission by the Honorable Attorney General. We are saying, my Lord, that this particular Constitution is very elaborate on the options available to a Kenyan who feels that any right that is enshrined in the Constitution or the Constitution itself is under threat. Article 165 of the Constitution. My Lord, my lady, we had an additional 20 minutes that had been donated to us.
That is so.
Yes. Mm-hmm. So, my lords and my ladies, we are saying that, my Lord and my ladies, that Article 22.1 of the Constitution, as read together with Article 23 and Article 165 of the Constitution, and Article 258.1 of the Constitution, allow anybody to file proceedings in any court in seeking public law remedies in the event that there is any action that has been taken by the president or the executive or anybody else that is violative of the Constitution, so that there is no lacuna in the form of the remedies that are available for anybody who feels that his rights or the Constitution itself is under threat of being infringed. And my lords, it is common ground that many suits have been filed challenging decisions by the president, including the example that I gave about the lockdown during the coronavirus. The Law Society of Kenya and its chairman went to court, and they managed to get an order saying that lawyers are also emergency workers, and they are entitled to also move around the country. So there is effective remedy available to anybody in the event that the president acts in violation of the Constitution or takes a step that is not allowed under the Constitution. The question then is, if there is an effective remedy in the Constitution to deal with situations where he strays out of the Constitution, what is the reason for wanting to name him personally? What is the purpose that will be served in naming him in the proceedings other than to embarrass him? And that is where, my lord, we urge that the court finds that in the circumstances of this case, A, there is sufficient remedy and effective remedy against circumstances where there may be claims that the president has acted outside of his powers, and that, my lord, in those circumstances, and the authorities that we have referred to you on this, the respondent in such proceedings is the Attorney General, not the president himself. There is absolutely no purpose that is served in suing the president in his personal name and requiring him to defend those proceedings using his resources. My lord, it's our submission, therefore, that the Court of Appeal disregarded the purpose of Article 143. And, my lord, for those reasons, we urge you to find that under the provisions of Article 143 of the Constitution, the president cannot be sued in his personal name in respect of anything that is done or not done in relation to the Constitution, and that in respect of private actions, that suit can only be filed after he leaves office. And so, my lord, just for the avoidance of doubt, we have said that the AG is not advocating for absolute immunity. We have shown circumstances under where suits can be brought to challenge executive decisions, but not to file them in the name of the president himself. Very quickly, my lord, I'll move on to the issue of popular initiative. There's a lot, my lord, that has been said on this. The AG has opposed the Court of Appeal's finding, and you'll find this at paragraphs 53 to 65 of his initial submissions dated 24th November 2021, and paragraphs 29 to 38 of his supplementary submissions dated 24th January 2022. But let me start off on this issue by saying this. The provisions of Article 257 of the Constitution that deal with popular initiative are not engaged until after the 1 million signatures of registered voters have been obtained. Prior to obtaining those signatures, there is no popular initiative. And so the steps prior, the actions that are taken prior, cannot constitute the popular initiative. The engagement of Chapter 16 for purposes of the popular initiative is in relation or only arises once the signatures have been obtained. And so, my lord, a lot of the discussion that was held before the Court of Appeal and the High Court was in relation with the steps that preceded the collection of the 1 million, the signatures of the 1 million registered voters. My lord, if you look at Article 257 of the Constitution itself, it does not prohibit the president or anybody else from getting involved in the process of popular initiative. And I must say this, my lords and my ladies, there seems to be an issue with people saying that don't just read the text of the Constitution. And my lord, the danger with that is that we may reach a stage where we now disregard what the people specifically said and try to read meanings into what we stated in the text. I think it is important that the beginning point in considering the provisions of the Constitution, the beginning point itself is the text. And in this case, the text does not admit of an exclusion of the president or anybody else from the process of popular initiative. But what is more of concern to us, my lord, is that in both the decisions of the High Court and the Court of Appeal, the president appears to have been stripped of some of his constitutional rights under the Constitution. Because, my lords, it is said that the president, as president, does not have the right to participate or even to initiate the popular initiative, meaning, my lords, that the right that the president has under the Constitution, and especially Article 38 on political rights, are in some way curtailed. In fact, one of the arguments was that the minute the president becomes president, he ceases to be a citizen. So I will address that. First of all, my lords and my ladies, it's important to note that under Article 19 of the Constitution, 19.3, the fundamental rights and freedoms in the Bill of Rights, which includes the political rights, belong to each individual and are not granted by the state. So that the rights that the president enjoys as a citizen are not rights that can be taken away from him, because they are rights that he has, they're inherent rights. He was born with those rights. And it says those rights are subject only to limitations contemplated in this Constitution. And the question we ask in the decision of the Court of Appeal, or even the submissions by counsel, what are the limitations in the Constitution to the president's rights to participate in any initiative, including the popular initiative? What is the provision of law that limits it? And why this is critical, my lords, is that if you look at Article 24, which is the only one that deals with the limitation of rights, it says a right or fundamental freedom in the Bill of Rights shall not be limited except by law, which means there would be a law that then limits the president's rights, because there is no dispute that the president has the right to vote. Why would we take his political rights to participate in a political cause? Secondly, under Article 24, Sub-Article 2, it says, my lords, that in the case of a provision enacted or amended after the effective date, the legislation is not effective unless it specifically mentions the intention to limit the right to a fundamental freedom and the nature and extent of the limitation. But more importantly, Article 24.3 says, the state or a person seeking to justify a particular limitation shall demonstrate to the court, the tribunal, or other authority that the requirement of this article have been satisfied. Meaning, the only way that the rights of the president to participate in the initiative or the process in Article 257, the only way they can be limited is that the person who is seeking that limitation must demonstrate compliance with the provisions of Article 24 of the Constitution. No such demonstration has been done by any of the parties or by the Court of Appeal itself. And so which are these rights that we are saying the president enjoys and that cannot be limited? The first one, my lord, is Article 32, which entitles the president or any citizen of this country to the freedom to thought, belief, and opinion. Secondly, my lord, the president has the right, under Article 33(1)(a), to seek, receive, or impart information or ideas. So that, my lord, as the example given by my learned senior, if the president would want to support the popular initiative or an idea to amend the Constitution, he has a right to impart those ideas. He's entitled. So if you are to take away that right, the only way you can do it is by showing that the provisions of Article 24 have been complied with. In this case, no such compliance has been demonstrated. Article 38, my lord, empowers the president or any other citizen of this country to campaign for a political party or cause, so that if the president has campaigned on a platform that entails amendment to the Constitution, he is entitled, my lords, to campaign for that cause. That right cannot be taken away from him just because he has been elected as a president. And so, my lord, just by the fact that he took an oath of office, he did not lose his rights and freedoms. And, my lord, under Article, in fact, one of the examples that is given, my lord, is that under Article 137 of the Constitution, it says that the only person who can vie for president, it must be a person who does not owe an allegiance to a foreign power. And therefore, that means that the president's right to participate, or rather the president's citizen rights have been curtailed to the extent to which he cannot have dual citizenship. First of all, that provision relates to qualification for election as president, but more importantly, even if it's a limitation, then it's a limitation that is contained in the Constitution, and that is permissible. My lord, the other issue is regarding the history that led to the promulgation of Article 257 of the Constitution. This has been referred to. But let me say this, my lords and my ladies. First of all, it's important to note that there is nothing like a universal constitution, meaning there are no boilerplate provisions for the enactment of the Constitution. A constitution, my lord, is dependent on the circumstances and the context of each country. And, my lords, my learned friend, Mr. George Oraro, has gone through the history leading up to the enactment of Article 257 of the Constitution. And as he said, my lord, what it was meant to curtail is parliamentary dictatorship. There is a suggestion that this also meant the president's rights and powers are curtailed in some way. But, my lord, will notice that this is a reading into the report provisions that are not contained in that report itself. And the last question that I would want to ask, which, my lord, I think is pertinent on this issue, is while we are preoccupied, or the Court of Appeal was preoccupied with the question about him supporting an initiative, if a suggestion is made or a bill is introduced, for example, to reduce the boundaries of Kenya for any reason, can the president oppose it? And the simple answer must be yes. If the president feels that what is being suggested is inimical to the interests of the country, he has every right to oppose it. And if he can oppose, then surely he can propose. The last issue, my lords, that I need to talk about is the issue of whether the second schedule to the Constitution of Kenya was unconstitutional. You'll find this at paragraph 495A, Roman 12 of the lead judgment of His Lordship Justice Musinga of the Court of Appeal, where they upheld the findings of the High Court on this issue. We have addressed this issue at paragraph 66 to 92 of our submissions and at paragraph 39 to 58 of our supplementary submissions. And it's a humble submission that the learned judges fell into error and misdirected themselves in making the determination that they did for the following reasons. One, my lords, it's a fact that a comparison between the provisions of the second schedule, of the Constitution of Kenya 2010 and the retired Constitution will show that under Section 42 of the retired Constitution, the Electoral Commission of Kenya was the one empowered to determine the number of constituencies and the demarcation of the boundaries. This power was taken away in the Constitution of Kenya 2010 at Article 89. Specifically, the power, my lords, to create new constituencies was taken away from the ECK. But what is critical for purposes of this discussion is that the fact that the number of constituencies and their distribution has a direct impact on the issue of fair representation and equality of the vote under Article 81 of the Constitution. In fact, in the revised report of the proposed boundaries of constituencies and wards, which was submitted by the IEBC to Parliament on the 9th of February 2012, it is document 1 in the second supplementary bundle of the Attorney General's second supplementary bundle of authorities. In the observations, which you'll find at page 36 of the bundle, one of the observations made was that the reports that were given by the people showed that they were influenced by the trend that resource allocation and access to government services is linked to electoral boundaries. And so, my lord, the observation with regard to representation, it was noted that the allocation of proportional representation had led to heightened interest for additional seats. And lastly, my lord, there was a comment that the distribution of constituencies had become such a critical matter for Kenyans. In fact, my lords and my ladies, the report by the Kriegler report, now referred to as the Kriegler report, 2008, you'll find this at page 76 of the report. It's page 3014, volume 21 of the First Appellant's Bundle of Authorities. It noted that one of the causes of the violence in 2007-2008 was the issue of underrepresentation in Parliament. In fact, one of the points that they made at page 76 is that the weight of a vote cast in Lamu East was 18 times that of the vote in Embakasi, so that there was no equality of vote at the time that this report was written. And so the people deliberately removed the mandate of allocation of constituencies from commissions and reserved this for themselves. Why? Because the problem that was noted in the Kriegler report was brought about because the issue of constituencies was left entirely to the ECK, to an independent commission. And that is why it is necessary that when it comes to determination as to the number of constituencies and their distribution, it is a matter that can only be determined by the people themselves. My Lord, there is a suggestion that by this particular schedule suggesting the manner in which the constituencies will be done, that it amounted to dictating to IEBC how to carry out its mandate. My lords and my ladies will notice two things. First of all, the second schedule did not at all attempt to amend or delete any provisions of Article 89 of the Constitution. The provisions of Article 89 were left intact. The only thing that the second schedule said is that the population quota should be prioritized. My lords and my ladies, the prioritization of that particular requirement of the population quota cannot be said to amount to taking away or to taking over the role of IEBC. In fact, if you look at the second schedule itself, it requires IEBC to carry out its mandate of boundary delimitation, because that's the role that IEBC is supposed to play. The only thing that it was required is that in doing so, it must prioritize the population quota. And so, my lords, it's a humble submission that that particular schedule cannot be said to be unconstitutional because it did not place any restrictions on IEBC mandate in the manner that was suggested. My lords will notice that under Section 27 of the 6th schedule to the Constitution, in fact, what the people of Kenya had done in that case is that they had protected some 27 constituencies and said that when IEBC is carrying its work, it must not affect those constituencies, meaning that had it not been for that provision, those 27 constituencies would no longer be available. And so limitations on what the people require to be done, my lord, cannot be said to be a taking away of the powers of IEBC. But there is a particular issue, my ladies and my lords, that I used to say before I sit down. In the report that I've just referred, my lords and my ladies, to, at page 36, there are observations by the Independent Electoral and Boundaries Commission, and there are about 6. My lord, the first one, which is the bullet point number 2, talks about members of the public were critical of the alteration of boundaries of constituencies and wards, even where the primary objective was to ensure compliance with constitutional parameters. In many cases, the public were unwilling to accept alteration of boundaries based on constitutional parameters. Then the next bullet point, electoral boundaries are delimited for the primary purpose of ensuring effective representation. However, there is a general perception that delimitation of boundaries is linked to resource allocation. Then finally, the next bullet point at the end, the last sentence, it says that the view about electoral boundaries was influenced by the general trend that resource allocation and access to government services is linked to administrative boundaries and electoral boundaries. And so, my lords, it says that they were making recommendations to Parliament in considering the report to address ways of ensuring conformity with the principles of representation as envisaged under the Constitution. So you can see that even the IEBC itself recognized that the issue of allocation of boundaries is such a political issue that the resolution of that issue can only be done through negotiations and compromises between the people. And this is exactly what the people did. They said there will be 80 additional constituencies, and they agreed on the distribution of these constituencies. My lord, that is a power that the people clearly have under the Constitution. And so, my lord, on that basis, we urge the court to find that the people in the exercise of their rights under the Constitution can direct IEBC on how to carry out its mandate. Now, my lords and my ladies, the issues that confronted the Court of Appeal required, my lord, that the Court of Appeal would have regard, one, to the wording of the Constitution itself. It would have regard to the circumstances, which it's a very important issue. And the circumstances are contained in the reports that have been submitted to Parliament, and especially the Kriegler report, which specifically said that this issue about allocation or distribution of constituencies is a powder keg. It can lead to civil unrest in this country. And therefore, it cannot be that the people themselves, the best solution to it is to allow the people themselves to sit, discuss, negotiate, and agree on how these constituencies will be distributed so that it allows for a unified country. And so, my lords, we urge you to find that the finding of the court on these issues was erroneous and to allow the appeal as pleaded. I thank you, my ladies and my lords, for your patience, and I also thank my learned colleagues for contributing their time. Thank you.
Thank you very much. We will now move to the second appellant. You have 1 hour between yourselves.
May it please you, Chief Justice and members of the court, I have already introduced my colleagues we